We have to allow Mr. Fong to proceed on the ballot.
That was the argument attorney Brian Hildreth made in Sacramento Superior Court on behalf of his client, Bakersfield GOP Assemblymember Vince Fong.
The House will be in order.
It all comes after former House Speaker Kevin McCarthy announced in December he'll resign from his seat representing California's 20th congressional district by the end of the year. Fong later announced his candidacy for the Valley seat, but shortly after that, Secretary of State Shirley Weber said Fong was disqualified from running for Congress because he had already filed to run for re-election to the state assembly. Weber argued Fong was not allowed to withdraw from his assembly race to instead run for Congress because the candidate's filing deadline had already passed by the time Fong made his announcement for Congress. Fong sued Weber, arguing she overstepped her power.
The Secretary of State does not have the right to determine the outcome of election. The voters in the 20th Congressional District have the right to choose the candidate of their choice to represent them in Congress.
In the court hearing presided by Judge Shellyan Chang, Fong's attorneys argued he can run for two offices at the same time, but Weber's attorneys argued California Elections Code 8003B specifically states no person may file nomination papers for more than one office at the same election.
I don't think the court needs to look beyond Section 8003B, which for 110 years has been understood exactly how the Secretary applied it here as prohibiting a candidate from simultaneously holding two offices in the same election.
But Fong's counsel argued there is already precedent for such a case, pointing back to Joseph Walker McCorkle, who served both in Congress and the state legislature at the same time in 1851.
As we have with Mr. McCorkle, we've seen it happen before. We've seen somebody have two seats simultaneously in both elected bodies.
I just don't see how practically somebody could be serving in Sacramento at the same time they could be serving in Washington, D.C. That just doesn't seem possible.
In the event that there is some ambiguity, we always have to defend the right to run for office. We have to allow Mr. Fong to proceed on the ballot.
The judge in the end agreeing with that, releasing this ruling saying Fong can appear on the 20th Congressional District ballot.
I think Assemblyman Fong has to be very pleased.
McGeorge School of Law adjunct professor Chris McKaylee reacting to the ruling.
Well, it was a relatively straightforward decision that she wrote, basically rejecting the Secretary of State's position that Elections Code Section 8003 precluded Assemblyman Fong to be running for Congress. I would think he would be very pleased with the outcome of today's decision.
And so Fong getting exactly what he wanted. Primary election day is March 5th, 2024. Reporting outside the Sacramento Superior Courthouse, covering local news that matters, Eitan Wallace, Fox 40 News.